Dunford and that other fella, Damien Schiff, uh, senior attorneys at Pacific Legal Foundation. Exciting week at the court. We had an opinion that we were waiting for here at PLF and has made some waves across the country in Childs versus Salazar. We had a argument, landmark in more than one way, on birthright citizenship. Some other additional arguments, maybe less interesting, and also had a grant. That's going to be the run of the show today. We'll start with the moment and talk about the birthright citizenship argument. We'll move on to the other oral arguments, talk about Childs, talk about the grant that happened this week, and we'll end with a little trivia for my fellow colleagues, see if they're up on their Supreme Court knowledge. But let's start with the birthright citizenship argument. Damien, can you just lay out what was the case about, sort of specifically and legally?
Well, I didn't realize that I was going to have to provide substantive comment. I thought this was just going to be my...
You're not just a pretty face, Damien.
Yeah, well, as I understand it, the president issued an executive order that applying prospectively would deny citizenship to those persons born in the United States, I think at least whose mother is not a lawful permanent resident. And the order was challenged successfully in the lower courts as a violation of the 14th Amendment's grant of citizenship to those born in the United States and subject to the jurisdiction thereof. And the president successfully sought cert review in the Supreme Court.
Right, and that's sort of the key. The 14th Amendment has this clause that says persons born and reside in the United States and subject to the jurisdiction of the laws of the United States. Why is that clause at issue here, Oliver?
Well, actually, it doesn't say subject to the laws, and that's kind of one of the disputes. It says subject to the jurisdiction hereof, meaning the United States. And so the question is whether that means kind of prosaically what you said, merely subject to the laws, and like anyone who's in the country, you have to follow the laws where you are. Or, as the Solicitor General argued, if it means something more, if it means that you have allegiance to the United States. And so the part of the dispute is whether the 14th Amendment adopted the common law understanding, which is basically if you're born on the soil, then you are subject to the laws thereof. And the Solicitor General pushed back and said, no, because that means allegiance to the king, and that's different. We have a different understanding. We have a Republican, small r Republican understanding of sovereignty and allegiance, and that's not what the framers of the 14th Amendment meant.
Yes, I was struck. I'm sure we'll jump around a little bit here, but I want to just start with where I thought was clever that the respondents' counsel started. In her opening statement said something to the effect of every school kid in America knows and can recite that if you are born in America, you're an American citizen. And I think that's true. Like, I remember when I lived in Germany for a number of years and taught American history there, and it sort of goes without saying that that's one of the things that separates America, at least, was the belief, or at least taught to me, that if you are born in America, you're an American citizen. And I remember giving them the analogy of, like, if you're flying over American airspace and you give birth in an airplane, that you're an American citizen. And they just thought this was crazy and they couldn't believe it, but that was what was unique about being America. But maybe it's not so clear as a matter of historical record, and maybe there is some, well, maybe that's where we should start. Is the president's view crazy in that we've been for 150 years since the 14th Amendment was adopted? Is it just ludicrous, or is there a historical basis for finding that subject to the jurisdiction thereof means more than what we've done for the last 150 years?
I mean, It's been almost, 90 years since Wickard v. Filburn. It's crazy to question the scope of the federal government's Commerce Clause power. No, it's funny, Mr. Thompson, you should start off with that opening from Ms. Wong, who is the director of the ACLU, who is arguing counsel, because I noted that too, and I thought it was a mistake, precisely because even the respondent's own argument admits that no, actually, just because you're born in the United States doesn't mean that you're automatically a citizen. And I came away from the argument thinking that if you want to become a citizen of the United States, make sure that your parents are not foreign ambassadors. Because it sounds like for some reason nobody really wants the children of ambassadors to become citizens. But I make that just to say that I agree that there is a long sense dating back to case law from the late 19th century from the Supreme Court and statutes from the 40s and 50s that assume that more or less, if you're born here, you are a citizen. And I think the Solicitor General himself even acknowledged it's sort of a revisionist argument that they're advancing. Now, to me, the challenge on both sides here is the sort of enigmatic nature of the language, subject to the jurisdiction thereof. And both sides, I think, acknowledge that, well, you can't take that literally, meaning that, you can break the laws, you have to follow the laws, something like that. There has to be something more. And the question is how many exceptions there are. Do you even consider them exceptions, or are they somehow sort of built into the nature of jurisdiction? And that's where most of the fight is. But it doesn't seem implausible to me to say that there has to be, some sort of that to be subject to the jurisdiction thereof might require more than just simply physical presence.
Yeah.
And the question is how much farther than that can you go? And that's where I thought most of the argument was focusing on.
Mm-hmm. Oliver, you mentioned allegiance being the thing that Sauer, the Solicitor General, sort of believes subject to the jurisdiction thereof means some sort of allegiance. Does that mean a la Michael Scott in The Office, when he declares bankruptcy, you declare allegiance, you pledge to the flag, and then all of a sudden you satisfy?
Well, part of the issue is how do you figure out a baby's allegiance when he's born? And someone said, I think Justice Jackson, what are you going to depose pregnant women about their intent? So there is a kind of a factual, if the Solicitor General's argument is correct, there is kind of a factual question here. How are you going to figure that out? And on the other side, Justice Barrett asked the Solicitor General, well, what about slaves who were forced to come to the United States? Do we presume they have allegiance to the United States? Presumably the people who were dragged here on boats, and when they came to shore, their immediate response would probably be, no, I don't have any allegiance here. I want to go back home. Mm-hmm. And his response there wasn't great. It's just like, well, they're covered, because we don't want to admit that they couldn't be. But
right.
So
well, if I may say, Mr. Dunford, on that point though, I thought he actually had a good response, which was allegiance is based upon domicile, and that in the antebellum South, basically all the states, and he cited Mississippi as representative, had states that said that all slaves' domiciles are considered in the state, regardless of personal intention. So the idea is that as a legal matter, they all had domicile, therefore they all had allegiance. Now that might be a stretch, but I mean,
yeah, and that domicile question came up over and over again. Because of the I forget the
Wong Kim Ark
opinion. And there the question presented involved domicile. At least it said whether the children of Chinese nationals domiciled in California are citizens. And the Ms. Wong, as you pointed out, Damien, the ACLU lawyer for the respondents, said that was just an assumed fact or a stipulated fact, mm-hmm. But that wasn't part of the holding. Justice Alito said, well, here's the question, and the court said the answer to the question presented is So, sometimes it's hard to figure out what the court's holding is. In this case, the court said it, here it was. And so the question was whether the domicile status of the Chinese nationals in that case was dispositive or went to the holding of the case. I don't know. I haven't read the case. Justice Kagan at one point said, well, yeah, the opinion said that. It says a lot of things. It was a long opinion. But then she also pushed back later when she questioned Ms. Wine. Said, it wasn't simply a stray comment. It's used, the term
20 sometimes.
It's used over and over and over again. So what does it mean? Interesting exchange on both sides.
It wasn't. I didn't think. I mean, her response to Alito saying, the justice lays out the QP and says we answer it yes this way, because it includes domicile in there, and I mean it's pretty compelling that is the holding. Her response, I mean maybe it requires one to go back and read Wong Kim Ark. As Damien, have you read Wong Kim Ark?
I have not.
But her response, which didn't strike me as all that compelling, was, well, the rule of law that comes out of that to reach the answer to the QP can only be such that birthright citizenship is allowed. So, but isn't that sort of like the definition of dicta? Like if that's where the reasoning will lead you, but it is not necessary but it's not a necessary component of the maybe it's not dicta, but it's like it's certainly stretching what the holding is. And I don't know that she has the better of that particular argument.
I think there was a part where Justice Alito was asking the Solicitor General about how you have the problem of illegal immigration now, which wasn't really present at the time that the amendment was adopted, and that it doesn't seem implausible to say that you could have somebody who's not legally present here, but who is effectively domiciled. And in terms of the Latin domus, they actually, people have a house and they might have lived here for, 30 years. Mm-hmm. And to say that they're not domiciled for all purposes of that seems to be a bit of a stretch. And so when you have Justice Alito asking a question like that, it does suggest to me that domicile, at least as the government was advancing, is probably not going to be accepted.
Yeah. Well, Alito will also sort of push back on the other side, though, because he said what they meant with domicile, one plausible interpretation of why that appears 20 times in the opinion, is that you had these two different classes of Chinese immigrants in America. You had domiciled immigrants like Wong Kim Ark, who were doing all they could to show allegiance to America and make it their home and domicile here. And you had other Chinese immigrants who were maybe treated less favorably and brought over on boats to build the railroad and had no allegiance to America and would never have considered themselves to be American and were just going to go back once the railroad was built. And maybe that's why domicile appears so heavily in the opinion.
He also suggested and this is to the ACLU lawyer, that maybe the justices were trying to make their opinion more palatable to the American public. By saying
that was Jackson's response to Alito.
Well, yeah, and I was going to say the ACLU lawyer at first disagreed with Justice Alito, and then when Justice Jackson put the question to her, she's like, "Oh yeah, no, that makes perfect sense."
Yeah, well, yeah. Justice Jackson's point is like, well, maybe you're right, Justice Alito. That is why domicile appears so often, but that doesn't mean that it was necessary to its holding. It could just be, flavor or flourish that the court put on there to make it more palatable to the American people. And I think both of those are plausible, frankly.
Yes.
Those are both plausible. Damien, you mentioned briefly the Latin domicile, whatever, but back to Latin, Justice Barrett was very interested in the two different sort of historical bases for citizenship. I think jus sanguinum or whatever, and jus territorium. I'm not getting them right, but can you help us understand what those are all about?
First of all, could you say the correct Latin before we?
Jus soli and jus sanguinis. So jus soli is the right of the soil, the law of the soil. The idea that's traditionally ascribed to the English monarchy, that if you're born under the domains of His Britannic Majesty, then you are a subject thereof.
His Britannic Majesty.
His Britannic Majesty. Jus sanguinis, law of the blood, is the theory of citizenship prominently espoused by France and I assume other civil code countries, whereby citizenship is based upon not where you're born, but on the citizenship of or nationality of your parents. And I think in this case, both sides agree, or both sides agree that the 14th Amendment adopts at least a modified version of jus soli. And the question is how modified?
I think Justice Barrett, don't mean to interrupt, thank you for explaining those better than I understood them. Justice Barrett put it to Sauer that his was, maybe it's a modification of the jus soli, but it was like such a modification that it almost started looking to be like jus sanguine or whatever it is. And so it would have been weird at the time for the Congress adopting the 14th Amendment to sort of create this new doctrine of citizenship and not say that they were doing that. Like you would have thought that they would have chosen A or B and not like A modified significantly to almost look like B.
Well, and Sauer would say that we know already from the text of the 14th Amendment that they are rejecting English jus soli, because if it were just English jus soli, they would have just said born in the United States. So the subject to the jurisdiction thereof obviously indicates a departure to some extent. Now, again, the question is how much of a departure? I think that the challengers here would say, well, most of the departure was meant just to accommodate the fact that we had and still have a unique relationship to Indian tribes, and that the framers of the 14th Amendment were accommodating the peculiar relationships that existed here that didn't exist, say, with England. But I think the government was arguing that, well, it's much more than that, and I think the government's argument was focused principally on the idea of sojourners, temporary sojourners in the domain of the United States, even if here lawfully, their children are not considered citizens. That was what the framers of, that was another aspect in which the framers of the 14th Amendment wanted to depart from the British.
Where did that come from, though?
So that sojourners are not.
I mean, where did Sauer make that argument that that's what the 14th Amendment meant?
It might be because he cited more than once Senator Trumbull's introduction of what became, and from what I gathered from the argument that was relevant, something that he said, but also he mentioned a few times these 12 or 14 treatises that they have from the time of the enactment of the 14th Amendment to the early 1920s that also said that temporary sojourners are not, the children of temporary sojourners are not automatically citizens.
One thing I thoroughly enjoyed was listening to the lawyer from the ACLU, Justice Jackson and Justice Sotomayor, tripping over themselves to say how wonderful the English common law is, citing to Kent's commentaries and all these other authorities. It was heartwarming, and I hope that they continue that in the future.
Well, I'm sure that they would. I'm sure that is a principled stance that they will use to decide future cases.
It is interesting, though, how prominently the phrase original public meaning was used without any hint of controversy or nose holding on both sides.
Yep.
It really does show you how much the paradigm has shifted over the last several decades, because that's just simply how you argue these cases.
Predictions on the outcome here?
I think the administration loses. I think at least Gorsuch and Roberts join Kagan, Soto, and Jackson, and then it's a question of I think Barrett's out there too. So I think there's at least 6. Maybe Thomas. I don't know. His first question was about Dred Scott, and which is interesting. That clearly the idea was to get rid of Dred Scott and expand But maybe the question was that's it. That's all it meant. But anyway, so I think there's at least 6 to
What about
disagree.
Kavanaugh?
I don't know. He's always a tough
Yeah.
on these questions. So I think at least 6.
Damien?
I think the administration will lose, and I think that the best hope they have is a decision that rests principally upon the 1940s, 1950s INA and the
Yeah.
Supreme Court ruling, and leaves open the idea either that that maybe Congress through legislation could change the rule and the court's not addressing that, or maybe even through its Section 5 power, perhaps, alter it. Because I thought in particular when Justice Barrett was talking about how, well, can we at least analogize these exceptions so that they apply to new circumstances, even though we're not creating a new rule? And I think what she was getting at is the point that, if it was kind of commonly accepted that temporary sojourners could become citizens, their children, but that was assumed that they were temporarily here legally, that what if we had a new phenomenon as we do now of a lot of people here who haven't been gained entrance legally, can we come up with a different result there? So I think she was maybe wanting to leave a little room open for either Congress or the executive, and but I think the judgment's going to go against what the government is asking for. I think the court's going to reject.
Yeah, our PLF friend Ilya Shapiro, I know, was predicting that the court would just say that Trump doesn't have the power to unilaterally say this through executive order. I didn't see that come up at all.
It didn't. I was surprised. I thought it would a little more, but yeah.
Yeah, and you're right. There could be some sort of like leave open the ability for Congress to pass a statute. I don't think they're going to. I think they're going to say 14th Amendment allows this and actually make a constitutional holding here. I think there's enough votes for that. You're right. Barrett maybe would concur, but I think they still have at least 5, and I think Kavanaugh's probably on that side too, and maybe even Thomas. Could be an 8-1. I wouldn't be surprised if it's an 8-1.
Yeah, it could be. The only reason it might not be that expansive, but who knows, is just that this seems like an opinion Roberts will want to write since it's such a big deal, and he can, sometimes he makes these big swings and comes out with these huge constitutional rulings, but he can also very easily issue a narrow opinion.
Well, especially the Chief Justice is so fond of minimalism. I think,
right.
He might be, even if he doesn't write it, I think he would be suggesting a more limited ruling.
Well, remember, the chief had the best quip of the argument. I mean, usually he's not the one for his famous one-liners, but at this point, I don't even remember. He was talking with Sauer, who says, "Mr. Chief Justice, this is a new world. We have rampant illegal immigration, millions of people coming into the country, and we need tools to address." And Robert's quip is, "It may be a new world, General, but it's the same old Constitution."
Mm-hmm. Excellent.
So I don't know. We'll see. Be one of those opinions. I also don't think it's that hot that controversial of an opinion, in that this is what everybody has thought it was for hundreds of years. Now, there have always been, I remember even 20, 30 years ago, reading some scholars that said that the jurisdiction thereof language meant more than what we have interpreted. So I don't think it's a crazy argument. I just don't think there's just not enough there to change what is been the prevailing view of American constitutional law for my lifetime.
Yeah. One more thing about the switching stuff. There was one. I saw a tweet. Somebody said it was Jay Cost, who said it's interesting to see that you have the progressives arguing the original public meaning and all this stuff, and you have the SG and the Republican Party basically arguing for a living constitution here and how things are switched. But I was right. Someone else, a law professor, said that the administration is talking about, well, no other country has a regime like this, and the response was, well, yeah, but so suddenly the administration doesn't like American exceptionalism. It's just another kind of
Yeah.
Trump. The one thing that I am enjoying about the Trump era is he does bring these issues to the fore, and forever the Justice Jackson praising the common law. It's making people make arguments that they wouldn't have made before Trump.
Yeah. Good. Any thoughts on the advocacy here by either advocate?
No.
I mean, it seemed quite pedestrian to me. I mean, I wasn't impressed with either. I thought they were fine though. I mean, Sowers never really, I don't know, never really strikes me as the best advocate out there in the SG's office, and I didn't think. I mean, the SCLU president was fine, but not exceptional.
I thought they were both extremely well prepared.
Yeah.
Nothing surprised them, I thought.
Yeah. Well, I mean, you say that. I remember there were a couple times on the Indian question, Sauer, he's like, "Oh, I haven't really thought about that. Let me take some time to think about that." My gut reaction is, and you don't really hear that often, especially out of the SG.
That's right. Yeah, right. Yeah, good point.
My brother-in-law, shout out David Ashford, has asked that we comment on Trump's presence in the courtroom. Now, this is largely an unprecedented thing. Maybe it has happened before recorded history in American Supreme Court arguments. But I know we had talked about it previously, I think a little bit, when it was suggested that he might show up to the tariff argument. He never did, but he did. Like, breaking news the day of the argument, President Trump shows up to the Supreme Court.
How does he get in? I want to know if he was in line with Tommy Berry, waiting to get in with the regular. Although he's not, Tommy would get in through the Supreme Court bar. How does he get in?
Well, I heard, now, granted, I haven't read a lot about this. I read like the article my brother-in-law sent me and maybe one other thing, but that there's a special seat in the Supreme Court for the president when he shows up, or she.
Get out of here.
I read the same thing, that when there is the investiture of the justice whom the president has nominated or appointed, but that was in the VIP gallery, I think, and the president here was just seated in the regular in the front row of the regular public gallery.
Huh. Is that right?
At the beginning of the argument, Roberts didn't say anything, but of course they don't start the live audio until after the preliminary stuff is done, when they swear in new attorneys and things.
Right.
So does anyone know, did the chief say, "Welcome, Mr. President," or anything?
I haven't read anything that said that he did.
Yeah, I don't think I don't think his presence was acknowledged.
Huh. No, apparently he left after Sauer was done. I read somewhere.
I read that too. Yeah.
That would be. I mean, people usually don't get up and leave. Not to mention being the president of the United States, getting up and leaving during.
I was thinking that they stand up for when the justices enter. Presumably they stood up when Trump came in. So did they stand up when he left? And I didn't get to listen to it live the whole way through. So I'm just wondering, because when Sauer sat down, there's a when one lawyer stops, there's a little break so the other lawyer can get up, but it's not like a 5-minute break or anything.
No, it's like I listened to that transition. I didn't hear anything that noted that the president got up and left at that moment.
Yeah, no. So who knows?
Sort of like bigger picture, what do you think of the president showing up to a Supreme Court oral argument?
I doubt it has any effect on the justice's decision. I don't oppose it. It's kind of, I think it frankly shows respect for the other branch of government.
Plus, the case was Trump versus Barber. I mean, he is the petitioner.
Yeah.
So
yeah, I mean, but that's the case in 30 cases every term.
Well, right. That's true. Yeah, that's true.
Yeah, that was stupid, Damien.
Yeah, I mean, when this first came up with the tariff argument, my initial reaction was, that's a little bit unseemly. It feels like he's going there to influence the court. And there's a reason why we want these branches separate, and justices shouldn't be influenced by the president in that way. It's not appropriate. having like now lived through it, it seems like my misgivings were not well-founded. It doesn't seem like it affected anything. The operation of the argument went fine. I don't think they held their punches in asking General Sauer questions that were difficult for the administration to answer. And, maybe there is something to that, Oliver, that like actually having him there and not being a complete horse's ass like he can be sometimes, shows the respect that is due the court. And when they inevitably rule against him in this case, which I think they will, maybe no, I could be wrong, the fact that he was there and the fact that he listened to their arguments and the fact that he's going to accept the decision, hopefully, that the Supreme Court renders is good for the Republic.
Yeah, and Trump has, I think, I don't think there's been any Supreme Court decision or decisions otherwise that the administration has ignored for all of his bombast and all of the sky will fall predictions from the other side. He's been following the orders from the courts.
Yeah,
More than some lower courts, actually.
Yeah, but no, that's right. That's right. Now he's said things that he shouldn't have said about judges and things like that, but he's been following the orders.
Yeah, I agree with that. All right, let's turn to the other oral arguments this week. The first was Abu Manu. Did I get that right? Probably not.
Abu Manu.
Let me see if I can pronounce it. Yeah, Abu Amo versus United States. I'll take this one. This case dealt with an individual who was being prosecuted in San Francisco, the Northern District of California, for a crime that he largely perpetrated in Seattle. He had falsified a document and emailed that document to the FBI offices in San Francisco. And they tried to bring the charge for that violation of that statute in the Northern District of California, in San Francisco. Now, the argument that he is making is that this would violate his Sixth Amendment right under the Vicinage clause that requires that you be tried by a jury in the state and jurisdiction that the crime is perpetrated in. The government's argument in this case is essentially, well, he intended it to go to San Francisco, and that's enough of sort of a nexus to bring the charge in San Francisco. His response to that is everything that was necessary for me every element of the crime, intent and actus reus, any actions that he had to do, was completed wholly within the state of Washington, wholly in Seattle, and you could have prosecuted me there without even having emailed anything. And so therefore the case has to be heard in the District of Washington.
Yeah, it's a bizarre argument. Apparently the statute was a result of Enron. Mm-hmm. And the statute is something about creating a false document with the intent to obstruct an investigation. And so he, as you said, he drafted this phony invoice in Seattle, then emailed it to DOJ, and the DOJ was prosecuting the case out of Sacramento or San Francisco. And so the argument is that he intended to obstruct the investigation, which was being carried out in California. And as you said, his lawyers said, well, all the elements, and there was a dispute about whether the court should look at the elements or other things. I wasn't exactly, I didn't follow this completely, but basically his argument is I did everything in Seattle, that's where the crime should be. And the argument's like, what happens if he drafted the phony invoice, thought about sending it but never did? Is that enough? And his lawyers seem to say, yeah, that's enough. He could have been convicted.
Well, and the United States lawyers said that's enough too. Both lawyers would agree that that's enough, and both lawyers would agree that it's almost impossible to prosecute because you'd never know that he did it. Yeah,
and then you'd have to get did he have intent if he never sent it? I guess he had the intent to obstruct when he created it. So anyway, there's all those kinds of questions. And he was convicted on a bunch of other stuff.
Yeah.
And he's only challenging this conviction and purely on venue grounds. So I don't know. And Alito said this, this came out of Enron. This is a strange. So I think the one worry from the justices is how do we resolve this without opening up a can of worms on a bunch of other statutes that aren't this narrow, or at least aren't didn't arise out of a unique situation like the Enron fraud.
Damien, any thoughts?
I find it interesting that someone would think that the Northern District of California would be a tough venue vis-a-vis the Western District of Washington. I mean,
Yeah.
or maybe it's just simply because it's just one way to get another trial.
Yeah.
Yeah, there was a lot of discussion about the Declaration of Independence here, in that, part of the sort of the impetus behind the Vicinage clause is that, after the Boston Tea Party, the perpetrators were shipped off to England to face trial. And at one point in the solicitors, Alito, who seemed to be the only one that was at all sympathetic to the solicitor's argument here, said something like, counsel, maybe if your position violates the Declaration of Independence.
Does violence too.
Does
I think is what he said.
Does violence to the Declaration of Independence, you ought to find a new way to distinguish your case. This feels to me like a 9-0, maybe an 8, maybe Alito will try to salvage it based on some unique circumstance. But I think they're just going to say, on this statute, you need to be tried where it's done, and be a pretty narrow opinion like that.
Yeah, I agree.
Who here, raise your hand, can say, I gave a brief recitation of what the Vicinage clause says. Does anybody know the exact text?
No.
Well, I had it up here, but now I don't have it. But I bring it up to say, so it basically says there's two requirements of the Vicinage clause: is that you reside in the state and the jurisdiction where the crime has occurred. So famously, one of my law professors, my contracts professor, was it contracts? No, it wasn't contracts.
Criminal procedure?
No, I think he taught con law 2. I can't remember what he taught now. I know he was my FedSoc representative. Wrote an article called "The Perfect Crime" that he got really famous for a brief period while I was in law school, and it dealt with the Vicinage clause. He hypothesized a crime that someone commits a murder in the Idaho portion of the Yellowstone National Park, because in that Idaho portion there aren't any residents there. So you can't seat a jury in that state where the crime occurred, and also in the district of Wyoming, or wherever the Yellowstone is. So you can actually commit a crime, and it would be impossible to constitutionally seat a jury under the Vicinage clause.
Cool.
So when Mrs. Dunford goes missing, we know where to look.
That's right.
All right.
Now, is this professor still famous, or?
Joshua couldn't remember him.
It's Professor Brian Kalt. Shout out Brian Kalt. Famous. I think his law review article, if I'm remembering correctly, was actually optioned to Hollywood for a Hollywood script.
That's that's pretty. You think most law review articles have a shelf life of what?
Yeah.
18 months, maybe 2 years.
You would know more than I would.
Yeah, mine are forgotten almost as soon as I've written them. I co-write with you all.
So here I have the text of the clause. The clause says that you are entitled to an impartial jury of the state and district wherein the crime shall have been committed. And so the argument is, well, the state is Idaho, the district is the district of Wyoming or something, wherever Yellowstone is. And so because you can't seat a jury with both of those caveats being fulfilled, it's impossible to be tried. You have the right under the Constitution of those things. All right. We had two other arguments. Oliver, I'm going to let you drive the car on both of these. Let's start with Jules versus Andre Balla's Properties.
Jules is a arbitration case, Federal Arbitration Act, and the question is whether the Federal Arbitration Act does not itself provide jurisdiction, and so in this case, lawsuit was filed in federal court in New York, I think based on diversity jurisdiction. The court ordered a stay so that the parties, although not all the parties in the case, but so that the dispute could be arbitrated. After the case was arbitrated, parties went back to the federal court in New York to confirm the arbitration award. And the question is whether the court at that point had jurisdiction to confirm the arbitration award. Everyone agrees that the court had jurisdiction at the beginning, but the argument is that it was a different dispute later, because the dispute was not the employment dispute that originally allowed the court to have jurisdiction. Rather, the question was whether the arbitration award was proper. And again, the Federal Arbitration Act does not provide jurisdiction. And so the argument is, does the court retain jurisdiction? I don't think there's any dispute that if the court, if the case had been filed after the arbitration award, if that had been the initial filing of the case, the court in New York would not have had jurisdiction. And so the question is, does the court keep jurisdiction, even though it wouldn't have had original jurisdiction to rule on the arbitration award? And really,
I mean, yeah,
who cares?
I don't know. I find that at least mildly interesting. If you've listened to the argument, I have not. But my sense, given where this court comes down on sort of these unique jurisdictional disputes, is that the moment the court loses jurisdiction, the court would say there's no jurisdiction. But what was your sense of how the argument went?
Well, but the court didn't lose. I mean, arguably, the court never lost jurisdiction because it stayed the case. And so the question is, can they come back? And it's kind of can it just kind of clean up? The one party cited to 28 USC 1367, which talks about supplemental jurisdiction or not supplemental, but and that is based on a similar set of facts or the same set of facts. And so there were arguments about, well, but it's not the same set, but it all involves this employment question, but this is now an arbitration question or an arbitration award, and the question there is kind of like a court on review. It doesn't look at the underlying decision, it doesn't do a de novo review. It says, is the arbitration decision, is it enough under the arbitration law? So I don't know, the arguments were, well, does it really make sense to have them redo this? But it seemed to say that a lot of these cases go to state court. And so it didn't seem like that big a deal. There was one humorous aspect which I didn't realize until later, but one of the lawyers was Adam Unikowski, who's a well-known Supreme Court advocate, and he wrote he has a thing on Substack, and he wrote, I forget how long ago, but he apparently did some tests on Claude, fed in the briefs, and I guess maybe the opinions that were cited therein, and said, what do you think Claude could do as an advocate? And then he also used some programs to use the voice and everything else, and he said Claude did great. He said it was an above average advocate, and there's no reason not to do this. And he points out that in a lot of trial courts in the middle of nowhere, the clients would probably be better served to have an anyway. So when they did the seriatim, I don't know how you pronounce that anymore, round, Justice Alito said, Mr. Unikowski, should we just have Claude decide this case? And a few of the justices laughed out loud, so they'd obviously been talking about it. And he kind of said, no, of course, I put this case before.
That's interesting.
That's the beauty of arbitration, is you can have Claude, right?
That's probably true. That's right.
Yeah.
That's a good point.
All right. That's quite interesting. Pitchford versus Kane, I'll learn what that was about.
Pitchford was a Batson case, and so the question there is whether there's, when you're striking jurors, a defendant is entitled to a non-racist jury, of course. And so when the prosecution gets a number, both sides get to strike jurors, mostly for any reason or no reason, except that the prosecutor cannot strike juries based on race and use another excuse as pretext. And so the question, though, is whether the defense counsel preserved those questions for review. And everyone seemed to agree that the transcript isn't great, and that the defense counsel didn't do a great job, and that maybe even the judge didn't do a great job. And so, for example, there's a point in the transcript in which the judge says, "Yeah, you've made those Batson objections," but then Alito said, no defense counsel I know would have been this quiet. Every defense counsel I know would have been much more aggressive preserving these questions. And then there were arguments. Well, I agree that the Batson, at least that issue was raised, but maybe not the pretext objections. Those weren't raised. And Kagan said, well, now you're slicing the bologna very thin. And now I was on a webinar a few weeks ago discussing this case. And one of the panelists, this is not to toot my own horn, there was a panelist who's from Mississippi, where the case came out of, and he says that this prosecutor has been dinged before, I think by the U.S. Supreme Court, and maybe even the judge too. And so he thinks maybe the court is just wants to make sure that these guys get the message that you. And so one of the questions, though, is whether the judge has an affirmative obligation to ask the defense counsel, what are your arguments? Are you raising a Batson argument, and if so, what are they? As opposed to it's simply the job of the defense counsel to preserve the issues. And I don't know what they're going to do. It's again, everyone said this is not a great job by anyone involved here.
Yeah.
But the question before the Supreme Court is relatively narrow. The merits aren't before. It's just whether they were preserved at all.
Okay. We'll be looking out for that opinion. Speaking of opinions, we had one major opinion come in this week in the case of Childs versus Salazar. Disclosure, PLF filed an amicus brief in this case on behalf of Childs. The facts of this case are that Colorado has a law that prohibits talk therapy when it concerns licensed officials who want to unconvert or detransition individuals, either
or discourage transition,
from either gender transition or homosexuality. And the question before the court is whether a law that prohibits that sort of conversion therapy violates the First Amendment. And the court, in an almost a near unanimous 8-1 opinion, said that it does violate the First Amendment, that all that is the counselor here is engaging in is speech, and recognizing that maybe this form of therapy is dubious. It is nevertheless speech, and it is nevertheless protected by the First Amendment, whether it is done by a licensed professional, whether it is done in the medical setting, whether it is incidental to conduct, whether it is commercial. All of these sort of traditional caveats that Colorado wanted to throw on why it could regulate this particular speech, the court rejected all of them in a pretty thorough opinion, and even joined by Justices Sotomayor and Kagan, said that Colorado's law violated the First Amendment. Damien, what were your thoughts on the Childs opinion?
It's always amazing to me when I read these First Amendment opinions to think that, this is essentially political theory or common law judging. It doesn't, all these precedents point so many different ways. It's hard to separate the analysis from sort of the rightness or wrongness of the outcome. And I see somebody who's not very familiar with the First Amendment. But that being said, it is interesting to me that as we were discussing in our little pre-chat before our show today about how the First Amendment does seem to be particularly robust and particularly available to vindicating various rights that might otherwise be vindicated through other, now perhaps disfavored means. So, for example, economic liberty. That this is her job, and it's not causing anybody harm because people are only coming to her asking for the help, right? But of course, you don't bring a Lochner type substantive due process claim or privileges or immunities claim. You bring a First Amendment claim. And, you know, I mean, for example, we were just talking about with the citizenship case that both sides talking about original public meaning, but there was no discussion of original public meaning of the First Amendment. It was essentially all about the case law. It's a very common law approach, which, you know, that's fine, but it is funny how prominent that does seem to be in the First Amendment.
There's a little bit of discussion of not really original public meaning, but the court in the opinion talks about the need for anyone who wants to support a restriction on speech has an obligation to show some historical evidence of a similar restriction.
Correct. That's right.
Kind of like, frankly, the Second Amendment jurisprudence lately, that the presumption is you can own a gun, the presumption is you can speak, and those who want to restrict those rights have to show that there's some kind of history and tradition of the restriction that is currently in place. And again, this, as we were just discussing, Kagan and Sotomayor are all over this and support, you know, this kind of broad defense of rights against, you know, and it's the burden to show the historical restrictions. And on the Second Amendment, they're on the other side. That the presumption is that the restrictions are fine.
Yeah.
I agree with that. I want to push back a little bit on Damien. You're right that this focused a lot more on precedent than, say, the birthright citizenship case did. Although I will say that at least as much on original meaning of the 14th Amendment and what Wong Kim Ark means, I think those are both highly prevalent in that oral argument. And I say that to note that, like, the difference is that we have a robust history of First Amendment opinions upon which to sort of rely, whereas we have like a lone opinion on birthright citizenship upon which to rely.
Although the First Amendment cases, I think, are mostly from the last 120 years or so, right? I mean, we don't have a ton of First Amendment cases from the 19th century.
Yeah, but we have none on birthright citizenship from either era, and I think that also sort of is understandable, in that laws that restrict speech are just a lot more common and prevalent than are laws that disrupt or change one's birthright citizenship.
Well, and there weren't any immigration laws when the 14th Amendment was adopted, right? So,
right.
or nothing like what we have now.
And then sort of the final pushback I would say is that I think that, you know, over the last, you know, prior to the Roberts Court, there were a number of doctrines that evolved in the First Amendment context that one can say maybe were unoriginalist, and that is like the commercial speech doctrine, the professional speech doctrine, the government speech doctrine, the employee speech doctrine, and it feels like slowly but surely the Roberts Court is just getting rid of a lot of these exceptions to the First Amendment. Government speech is now, you know, save the case that I'm going to be petitioning the court on in next month, very narrowly construed. Commercial speech, I think we're waiting for that to be killed. I think NIFLA killed the idea of professional speech. So it, yeah, and you have Reed versus Town of Gilbert that says, you know, strict scrutiny for any content-based law. So in that respect, you know, where this court is going, I don't think, I mean, the strength in an 8-1 opinion is, and it wasn't like a mealy-mouthed opinion either. Even though it garnered 8 votes, it was a pretty strong one. One last note on why PLF got involved. We have 2 cases right now challenging telehealth restrictions by highly specialized cancer doctors in some prestigious hospitals across the country. And our argument that we're making there, as it concerns the First Amendment, is that all they are doing, they're not prescribing medicine in these calls, they're not providing treatment, they're not, you know, as I wrote in one of the briefs, cancer doesn't respond to a phone call. they're just talking to their either prospective clients or past clients that want follow-up consultations. And there's no reason why that should be allowed to be prohibited just because they are not licensed in, say, a particular state's medical licensure.
Well, speaking of licensure, the Colorado, in this case, admitted that the prohibition does not apply to non-licensed people. So you could talk to your friend or to a counselor who's not a licensed therapist and get the same kind of advice, and you wouldn't be subject to it. Now, on the other hand, I could easily see Colorado prosecuting people for conducting that kind of talk without a license and saying you are practicing therapy or without a license, which goes to your point, Joshua, about the doctors across borders who aren't licensed in a particular state but have been licensed in wherever state they're calling from. And lawyers face the same thing. There was, I think this is right, that California went after a lawyer once who, while on vacation in California, answered a couple of phone calls from clients, and the state said you're practicing law in California without a law license, which is all totally ridiculous. Having said all that, I agree with Damien in this respect. Again, the First Amendment is overrated, and I mean that not because the First Amendment is under protected, it's because the other rights are under protected. And so in this case, as Damien says, why can't someone talk to a therapist and get whatever the hell advice the person wants? But in this case, the other ridiculous thing which made Colorado look really stupid is, if you're a licensed therapist, you were allowed to encourage people to transition, but you were prohibited from discouraging people from transitioning or whatever. So it was clearly one way and not the other. And as Gorsuch said in the opinion, this isn't even the consensus now. I mean, it might have been the consensus like 2 years ago. It's not the consensus already. And it may not be in 10, 20 years. He pointed out the American Psychiatric Association, I forget what they did, but they basically said homosexuality was a disorder at one point.
Yeah.
And so you cannot, but the same reasoning would apply to professions like medicine itself, surgery and other things. I mean, they used to bleed people to make them better. So all these things, I think, and I agree with the opinion, obviously, but there is part of me thinking, look, this is professional. Yes, it's just talk, but talk is not nothing. So on the one hand, you can't say talk is this super important thing and it needs to be protected. And the other thing say, well, it's just talk, so it's not regulation of medicine or whatever else. Well, yes, it is sort of. So I don't know. I'm on the fence. I like the result, but I just have problems with the overall analysis.
You're crazy.
In the greater context of all the other rights in the Constitution.
I don't think it's that hard to draw a line between. I think it is a little bit ridiculous to say that I can talk to somebody in X state and tell them to, I don't know, go get LASIK eye surgery, or go get a root canal, because I'm not a dentist or an eye doctor, but somebody who is prohibited from doing so. That strikes.
Yeah,
pardon?
no, I agree with that. But I don't. Why is that a speech question? Is my point.
That's all that you're doing is talking.
Yeah, but you're saying, I don't know, at some point. But that's all you're doing when you say, here, take this medicine.
Yeah, I mean, I don't know. I mean, in some sense, yes, but that is also you're also sort of giving. You're only authorized to prescribe medicine because of the virtue of your licensure.
Yeah, but it's treatment is my point, and I don't think there's any much dispute that therapy is treatment. It can just talking can help people. So it's not.
Well, what about if it's shown that people who want this therapy, the talk therapy, is ineffective? So now they have to get this physical, whatever Justice Gorsuch referred to as sort of the next thing that would not be talk. And I think, Oliver, your point is that, well, if they're consenting people and they want to try this therapy, shouldn't the state also have an equally good reason to prevent them from doing it? And the only reason I would say one or the other is that, well, if it's speech for some reason, we really care about it, and that's the concern is that the First Amendment.
For some reason, it's because we have a First Amendment.
Right, I know, but that's kind of circular, because what is the First Amendment meant to, I suspect that what was in the mind of the framers of the First Amendment would have been political speech, not, you know.
Yeah, I'm a faint-hearted originalist on the First Amendment, as Scalia would say.
I think you guys gotta back the hell off and embrace the First Amendment. I'm all for advocating First Amendment, robust First Amendment protections should be applied to other rights that are guaranteed by the First Amendment. But let's not denigrate the First Amendment to get there.
No, only Oliver was denigrating. Only Oliver was denigrating.
All right. Well, it's a big opinion. Certainly one that we are great. You know, we're excited about where this case can go. I mean, if we can really have success on telehealth and really open up, some of the nation's best doctors to people across the country, that's going to have a profound.
Or AI.
Pardon?
Or AI.
Yeah, it will have a profound effect on health in America. So I'm hopeful that this case will lead to more successful First Amendment challenges, because the First Amendment is so important and great. All right, we had one grant this week. This was a case.
It's not another First Amendment case, is it?
No, this is Young versus Fulton Judicial District Attorney. Damien, it's interesting. We were just talking about this issue, and I feel like 2 weeks ago, about affirmative defenses and whether a defendant must plead affirmative defenses in its answer or they are waived. And now the court grants cert on it. Do you want to talk a little bit about this case?
I mean, I know nothing about this case. That's why I was hoping that you would be able to do all the hard work. But I mean, I thought the rule was pretty clear, that, and it's sort of a common law rule too, that affirmative defenses are essentially, they're kind of like counterclaims, because they're affirmative precisely because the person who's advancing them needs to establish facts beyond which have been asserted in the complaint. That's why they're affirmative. So if you analogize them to complaints, you have to ask yourself, well, then claims, and they probably should be pled for notice on the other side in order for them to conduct their own discovery with respect to that affirmative defense. And so I am surprised that this is an issue. But Mr. Thompson, you can probably fill us in on the facts.
I don't know a whole lot about the facts. I think it is an individual who's brought a civil rights claiming discrimination, I think, on pregnancy. And I think there's some exemption that certain staff would be exempted from that discriminatory provision, and the defendants in this case tried to invoke that exception but didn't do so at the time of the answer. And so the question is whether it is waived. Now, the reason why I think we were talking about this issue, Damien, a couple of weeks ago is, I mean, you have to deal with some of your Clean Water Act cases when you asked me about, but I just assume, I mean, I hadn't read the federal rules recently, and it's just struck me as the government gets to always do whatever they want. And so the fact that they didn't plead something in an answer would have never occurred to me that I could then call them out for that later on, that this affirmative defense that you failed to raise in your answer, you're now relying your whole case upon, because the government always wins those types of arguments. So the idea that the court may actually put some real teeth into the pleading requirements in an answer is somewhat comforting, although I will say the other thing the government does is they just plead every affirmative defense. It's laches, it's statute of limitations, and they put everything in there, and now they're going to continue to do that so that they don't waive. So I don't know how much weight it's going to be.
Yeah, as a former, not a defense lawyer, but I used to be on the other side and file and had to work on answers, and it's nerve-wracking, because on the one hand, if you throw the kitchen sink in, the judge is going to scream at you for wasting everybody's time. But if you miss one, then you're screwed. Now you can always move to amend and all that stuff, but yeah, it's a different. The other thing is you have 30 days. Now the government has 60, but you have 30 days to figure out the entire case and figure out what affirmative defenses there are. It's not easy.
Yeah, but yeah, you noted there is a Rule 15 procedure for amending one's affirmative defenses that I would imagine a court would grant if it were be a manifest injustice to not allow it.
Yeah, and if the parties have litigated it and done discovery on it, then there's no prejudice, and so
Yeah.
it's not the end of the world, but it is you know,
Yeah,
it's not nothing.
interesting. Yeah, I mean, that's a good point. I mean, look, I hate the government and don't usually see it from their perspective, but the idea that they need to know all their affirmative defenses ex ante does seem a little bit odd.
No, but on your larger point is the government does get to do whatever it wants.
Right.
There are also, I mean, frankly, there aren't that many affirmative defenses out. Most of them really kind of arise in contract law, but I mean, otherwise, most quote-unquote defenses out there, I would say, are not even affirmative. I mean, they're really just various arguments for undercutting the plaintiff's case in chief, in which case I think you're okay. No.
Yeah, that's a good point. If the courts would also, yeah,
Yeah.
discourage people from just throwing everything in there that's not an affirmative defense, that would be helpful.
Well, yeah, like standing, for example, you can't waive that one if you don't include it in your.
Well, and I wouldn't even call that an affirmative defense because that's the burden of the claimant to establish.
Right.
That's fair. Yeah.
Yeah.
That's a good point. Okay, well, we'll be watching that one. It won't be argued till next term, but certainly an interesting one. Any other thoughts on the Supreme Court this week before we get to your guys' trivia questions? Damien?
Let's wrap it up, as Damien would say.
All right, we're going to do a little bit on size of the court.
Potter Stewart.
How many times, gentlemen, has the Supreme Court switched how many people by statute sit on the Supreme Court?
3.
Damien?
Not including the original statute, I guess.
I'll agree with that.
It was 1, 2, 3, 4, 5, 6, 7, 8.
What? Did they go
8
back and
times.
forth?
Pardon?
Did they go back and forth?
They went back and forth a couple times. So originally, in the baseline, what is the number of justices on the Supreme Court?
6.
Very good, Oliver. 6. And in 1801, Congress passed a statute that changed it to how many?
7.
5.
Huh?
This is the famed Judiciary Act of 1801 that in other parts led to which famous case, Damien?
Marbury v. Madison.
Exactly. But the attempt to restrict the court to 5 failed as it was overturned by the subsequent Congress when Thomas Jefferson took office, much like Marbury's commission was never filled. So back to 6 in 1802, and in 1807, they expanded to 7. Do we know why they expanded to 7?
What year?
1807. It will be the same reason that they expand to 9 in 1837. Because they added a circuit. They added a 7th circuit, and then in 1837 they added an 8th and 9th circuit, so they upped it to 9. Because you remember at this time, the justices had to ride circuit. So each justice was at 9. Then in 1863, how many people were on the court? Did the Congress change it to how many?
47.
Well, I'll tell you this, you're moving in the right direction because they went to 10. There was a 4-year period where there were 10 justices on the Supreme Court, and this is the trivia of all trivias. Who was the only justice to ever be the 10th justice on the Supreme Court? And a further clue, he served for 34 years.
Tony.
No. It says in 1863.
Harlan.
Libertarian icon.
Stephen Field.
Stephen Field was the 10th justice. That lasted until 1866 when Congress shrunk it to 7. How did they take a court that was down from 10 and shrink it to 7? By statute, they shrunk it to 7, and as justices died or retired, they just didn't. There was no mandate to fill them. So they did this to block Andrew Johnson from being able to make any appointments to.
Well, that sounds good.
And then in 1869, when Grant was in office, they fixed it back at 9 and filled it with Grant's appointees, and Johnson never got an appointee on the court. And that's where we stand today.
Those are tough questions.
Yeah.
Yes. All right. Well, thank you for that walk along Supreme Court history. Thank you all for joining us for PLF Supreme Court Show. We'll be back at it next week. I don't think the court is actually in session, is it? But we never rest.
No,
Another,
and home opener tomorrow for the Guardians.
Pardon?
Home opener for the Guardians tomorrow.
Oh, okay. Well, maybe they can finally get to their 5th win, but the Brewers are already there. All right, Mr. Schiff, Mr. Dunford, thanks for joining me, and we'll be back soon. Thanks for listening.